The German nobility was a class of persons who, until 1919, enjoyed certain privileges relative to other people under the laws and customs of various parts of what is now Germany. Governments which recognized the conferred nobility included the Holy Roman Empire, the German Confederation and the German Empire. All legal privileges of the nobility were officially abolished in 1919 by the Weimar Republic, and nobility is no longer conferred or recognized by the Federal Republic of Germany. Former hereditary titles being allowed only as part of the surname. The nobility system of the German Empire was similar to nobility in the Austrian Empire, both having risen from the Holy Roman Empire and both ending in 1919, but Austria banned subsequent legal use of hereditary titles in any form, even aristocratic principles. In Germany, nobility and titles pertaining to it were recognized or bestowed upon individuals by emperors, kings and rulers of lesser rank, and were then inherited by the legitimate, male-line descendants of the ennobled person. In cases where families had been deemed noble as far back as historical records could document, the nobility was usually eventually recognized by a sovereign, confirming their entitlement to whatever legal privileges nobles enjoyed in that sovereign's realm. Noble rank was usually granted to men by letters patent, whereas women were members of the nobility by descent or by marriage to a nobleman. Nobility was inherited equally by all legitimate descendants in the male line. Most German titles of nobility were also inherited by all male-line descendants, although some descended by male primogeniture, especially in 19th and 20th century Prussia, and elevated twice, first to the hereditary title of Count, and then to the, in this case only personal, title of Prince in 1871. His children and future cadets of his family were counts. Upon promulgation of the Weimar Constitution on the 11th of August 1919, all Germans were declared equal before the law. On the 18th of March 1919, the Landtag of the Free State of Bavaria enacted the Gesetz über die Aufhebung des Adels, which eliminated all noble privileges, and henceforth forbade Bavarians from accepting foreign ennoblement. Other German states enacted equivalent legislation. The Bavarian Constitution of 1998 also bans the transfer, by way of adoption, of surnames containing formerly noble attributes. This caused an exceptional practice regarding surnames borne by former members of the nobility, whereas the gender differentiation in German surnames, widespread until the 18th century, colloquially retained in some German dialects, was abolished in Germany with the introduction of officially registered invariable surnames by the late 19th century. Former noble titles transformed into parts of the surname in 1919 continue to appear in female and male forms. Altogether abolished were titles borne exclusively by German monarchs, such as Emperor, Empress, King, Queen, Grand Duke, Grand Duchess, etc. However, former titles shared and inherited by all members of the family were retained but incorporated into the surname. For instance, members of the former royal families of Prussia and Bavaria were allowed use of Prince, Prinzessin, or Herzog, Herzogin in the cases of the former kings, queens of Saxony and Württemberg. The ducal title borne by non-ruling cadets of their dynasties before 1919, or Herzog, Herzogin for the six deposed Grand Dukes and their consorts. Any dynast who did not reign prior to 1918 but had held a specific title as heir to one of Germany's former thrones, along with any heir to a title, if nobility inherited via primogeniture, and the wives, were permitted to incorporate those titles into elements of the personal surname. However, these titles became extinct upon their deaths, not being heritable. With the demise of all persons styled Crown Prince before 1918, the term Crown Prince no longer exists as a legal surname element. Traditional titles exclusively used for unmarried noble women, such as Baroness, Freiin, and Fraulein, were also transformed into parts of the legal surname, subject to change at marriage or upon request. All other former titles and nobiliary particles are now inherited as part of the surname, and remain protected as private names under the laws. Whereas the title previously prefixed the given and surname, the legal usage moves the former title to the surname. However, the pre-1919 style sometimes continues in colloquial usage. In Austria, by contrast, not only were the privileges of the nobility abolished, but the titles and nobiliary particles as well. Some states within the Holy Roman Empire had strict laws concerning proper conduct, employment, or marriage of individual nobles. Failure to comply with these laws could result in temporary or permanent Adelsverlust. Until about the early 19th century, for example, it was commonly forbidden for nobles, theoretically on pain of Adelsverlust, to marry persons of low birth, i.e. commoners. Moreover, nobles employed in menial labor could, theoretically, lose the noble rank, as could nobles convicted of capital crimes. Adelsverlust only concerned the individual who was in violation of noble laws of conduct, meaning that their kin, spouse and living children were generally not affected. Various organizations perpetuate the historical legacy of the former nobility, documenting genealogy, chronicling the history of noble families, and sometimes declining to acknowledge persons who acquired noble surnames in ways impossible before 1919. Nobiliary particles. Most, but not all, surnames of the German nobility were preceded by contained the preposition von zu as a nobiliary particle. The two were occasionally combined into von zu. In general, the von form indicates the family's place of origin, while the zu form indicates the family's continued possession of the estate from which the surname is drawn. Therefore, von zu indicates a family which is both named for and continues to own their original feudal holding or residence. However, the zu particle can also hint to the split of a dynasty, as providing information on the adopted new home of one split-off branch. For instance, a senior branch owning and maybe even still residing at the place of the dynasty's origin might have been called of a town furthermore, while a new, junior branch could then have adopted the style of, say, of a town at Beville, sometimes even dropping at, simply hyphenating the names of the two places. Other forms also exist as combinations with the definite article, e.g. von der or von der vom, zu der zur or zu der zum, particularly between the late 18th and early 20th century when an increasing number of unlanded commoners were ennobled. The von was typically simply put in front of a person's surname. When a person by the common occupational surname of Mayer received nobility, they would thus simply become von Mayer. When sorting noble, as well as non-noble, names in alphabetic sequence, any prepositions or title are ignored. Also name elements which have developed from honorary functions, such as Schenk, are overlooked. Nobiliary particles are not capitalized unless they begin a sentence, and then they are usually skipped, unless this creates confusion. In this, the German language practice differs from Dutch in the Netherlands, where the particle van is usually capitalized when mentioned without preceding given names or initials, or from Dutch in Belgium, where the name particle van is always capitalized. Uradel, a family whose nobility dates back to at least the 14th century, may be called Uradel or Alter Adel. This contrasts with brief adel, nobility granted by letters patent. The first known such document is from September 30, 1360, for Weikefrasch in Mainz. Hochadel were those noble houses which ruled sovereign states within the Holy Roman Empire and later, in the German Confederation and the German Empire. They were royalty. The heads of these families were entitled to be addressed by some form of majesty or highness. These were the families of kings, grand dukes, reigning dukes, and reigning princes. The Hochadel also included the empire's formerly quasi-sovereign families whose domains had been mediatized within the German Confederation by 1815, yet preserved the legal right to continue royal intermarriage with still reigning dynasties. These quasi-sovereign families comprised mostly princely and comital families, but included a few dukes also of Belgian and Dutch origin. Information on these families constituted the second section of Justice Perthes' entries on reigning, princely, and ducal families in the Almanach de Gotha. During the unification of Germany from 1866 to 1871, the states of Hanover, Hesse-Kassel, Hohenzollern-Hechingen, Hohenzollern-Sigmaringen, Schleswig-Holstein and Nassau were absorbed into Prussia. The former ruling houses of these states were still considered Hochadel under laws adopted by the German Empire. In addition, the ruling families of Hohenzollern-Hechingen and Hohenzollern-Sigmaringen recorded the dynastic rights of a cadet branch of the royal house. If Prussia, after yielding sovereignty to the royal kinsmen, the exiled heirs to Hanover and Nassau eventually regained sovereignty by being allowed to inherit, respectively, the crowns of Brunswick and Luxembourg. Niederadel, nobility that held legal privileges until 1918 greater than those enjoyed by commoners, but less than those enjoyed by the Hochadel, were considered part of the lower nobility and Niederadel. Most were entitled, only making use of the particle von in the surnames. Higher-ranking noble families of the Niederadel bore such hereditary titles as Ritter, Freiherr and Graf. Although most German counts belonged officially to the lower nobility, those who were mediatized belonged to the Hochadel, the heads of the families being entitled to be addressed as Erlaucht, rather than simply as Hochgeboren. There were also some German noble families, especially in Austria, Prussia and Bavaria, whose head bore the titles of First Herzog. However, never having exercised a degree of sovereignty, they were accounted members of the lower nobility. Titles and ranks. Reigning titles. The titles of Elector, Grand Duke, Archduke, Duke, Landgrave, Margrave, Count Palatine, Prince and Reichsgraf were borne by rulers who belonged to Germany's Hochadel. Other counts, as well as barons, lords, knights were borne by noble, non-reigning families. The vast majority of the German nobility, however, inherited no titles, and were usually distinguishable only by the nobiliary particle von in the surnames. 1. The prefix Reichs indicates a title granted by a past Holy Roman Emperor. These titles conferred higher precedence than that associated with other titles of the same nominal rank. Freiherrn indicates a baroness by birth. Non-reigning titles. The heirs to sovereigns at a headship of mediatized families prefixed the title with erb, meaning hereditary. For instance, the heir to a Grand Duke is titled Erb Grossherzog, meaning hereditary Grand Duke. A sovereign duke's heir was titled Erbprinz, and a prince's heir might be titled Erbprinz or Erbgraf. The prefix distinguished the heir from similarly titled junior siblings and cadets. The heirs to emperors and kings were titled Kronprinz, while the heirs to prince-electors were titled Kurprinz.